What a good plaintiff attorney does is they say, okay, well, why don't we try to get this done on motion? Because if you can win that argument on motion, then when you go to trial, the question isn't whether or not you suffered a serious injury, but the question is to the jury, how much money do you give this person for past pain and suffering, future pain and suffering, medical expenses, wages, right? So in this particular case, what happened, and why it's important, is that they moved for summary judgment saying that the injured person, and the facts aren't clear, but you could pretty much assume they didn't go back to work for a period of anywhere 3 to 6 months following the accident. And then the plaintiff produced an affidavit from a doctor, from medical records involving treatment that occurred 1 year post-accident, stating that the person was disabled and couldn't go back to work. And they got summary judgment out of the lower court. The defendant, the insurance represented by an attorney paid for by the insurance company, appealed it. What the appellate division said, which is very noteworthy, is that, as you know, one of the things they said is that you can't move for summary judgment on the issue of whether or not you have a permanent or serious injury or threshold injury until full discovery has occurred. So in this particular case, the defendant didn't perform a medical examination, so they said it was premature. But really what's important, and really something you need to be aware of, is that the appellate division said, in any event, you didn't make a showing that you sustained this serious injury on papers because there was no evidence contemporaneous, that is around the time of the accident, showing that you had medical treatment and that you did suffer these injuries, and that your inability to perform services work for the first 90, 180 days is related to an injury or a condition that's contemporaneous from the accident.